Almost 3 weeks into the impeachment trial of Chief Justice Renato Corona, the House prosecution panel announced it's going to present 100 witnesses. This prompted the presiding senator judge to call for a pre-trial to save time. Rappler spoke with lawyer Tito Lopez on the need for a pre-trial, the nuances of proof, and court rules. Atty Lopez is a partner in Sycip, Salazar, Hernandez and Gatmaitan, the largest law firm in the Philippines. He is part of the firm's litigation department and he lectures on evidence at the UP College of Law.
I think one other item that would make this whole thing orderly would be some sort of preliminary conference, which would be akin to a pre-trial in an ordinary civil case, where the parties with the court would basically go through the case and say, what do we really dispute, first of all? What are we disputing? What are we admitting? What facts do we not really dispute in good faith so that we don't need to have a trial on those facts? Let's just have a trial on the facts that are denied. In an administrative proceeding, it's usually a proceeding that's conducted by a quasi-judicial agency or an administrative body to arrive at certain findings or to resolve certain controversies. And the procedure there is generally less strict than it would be in a normal or typical court trial. In a civil case, you are governed by the rules of court, the rules of evidence, by the law on pleadings, and the procedure there is a little more formal, a little more strict, and more controlled, so that the issues can be laid out. The issues can be joint, which is to say the parties can say what they admit or not admit, and then the court can try those matters which are not admitted. In a criminal case, there are various stages. Well, principal stages really are the preliminary investigation and the trial proper, where all sorts of safeguards are built into these stages to protect the rights of the accused, arising from the presumption of innocence. Substantial evidence is what you require in an administrative case. Preponderance of evidence is what you require in a civil case, and proof beyond reasonable doubt is what you require in a criminal case. So you're right, this is a rare animal, this impeachment case. The Latin word they use, the term they use is sui generis. And there is no established evidentiary standard for it. An appropriate standard would be something between preponderance of evidence in a civil case and proof beyond reasonable doubt in a criminal case. You would want that any conclusion you make, any judgment you make, would be based on facts that you arrived at using a standard of evidence that is more thorough, more rigorous than for an ordinary civil case. But unlike a criminal case, it doesn't involve life or liberty. Many writers have said that what's involved is a high office. And although it's a serious matter, it is not a life or liberty that's personal to the office holder. Public office being a public trust.